Okay, good morning, good fellows. It is my honor to introduce the Honorable John Jeffery, MP, one of South Africa's Deputy Ministers, the Deputy Minister of Justice and Constitutional Development. Mr. Jeffery is an admitted attorney and holds a BA and LLB degrees, as well as a postgraduate diploma in environmental law from the University of Natal. He is a member of the ruling party, the ANC. He describes growing up as a white South African in the late 1970s and seeing the injustices and human rights violations under the previous regime as being the driving force in him joining the liberation struggle and becoming actively involved and engaged in politics at university. After South Africa's transition to a constitutional democracy in 1994, Mr. Jeffery became a member of the KwaZulu-Natal Provincial Legislature, where he chaired the Environment and Conservation Portfolio Committee. Mr. Jeffery has been a member of the National Assembly of Parliament since 1999. He's a former member of the Justice and Constitutional Development Portfolio Committee, where he was instrumental in shaping a number of pieces of legislation, such as the Child Justice Act, the Prevention and Combating of Trafficking in Persons Act, the Protection from Harassment Act, the Superior Courts Act, the Protection of Personal Information Act, and the Legal Practice Act. He served as parliamentary councillor to the President and the Deputy President from 1999 until July 2013. Mr. Jeffery was appointed as Deputy Minister of Justice and Constitutional Development in July 2013. His constituency is in KwaZulu-Natal. Mr. Jeffery has said that he will speak to us for about 15 minutes, after which we will have a 45-minute question and answer session. That is it.
Thanks very much, and good morning, everybody. The 15 minutes is, you make it sound so precise. I don't have a speech. I basically was not quite sure where to pitch things, and I wanted to leave as much time to you to be able to ask questions. I mean, I understand your session today or this week is on public policy. So it may be useful to speaking a little bit about that. I was actually invited to speak to you about being a member of parliament and being a deputy minister, which I thought was a bit boring, but I can say a few words on that if that's what you want. You do know the electoral system, the proportional representation, the whole debate around should you have constituency-based elections or should you have proportional representation. An argument that if you have constituency-based systems, you get more direct contact with the electorate. We opted as a country to go for proportional representation, pure proportional representation, so the people elected to the National Assembly reflect the percentage support that the party got. And that's quite different, say, to a country like Britain, which is where our system emerged from. We've got a lot of similar traits to the Westminster system. But do you know that Britain, since there was a universal franchise, since everybody could vote, do you know that Britain has never had a government elected not by the majority of voters, worse than that, elected by the majority of people who voted? So never. Okay, so only the people who went off and cast their ballots, not all the people who were registered and didn't bother to pitch up, just the people who went off to cast their ballots. The government never got over 50% of the vote, ever. Okay, the closest was, I think, after the Second World War, the Labour government. Clement Attlee got 47 or 49% of the vote. Margaret Thatcher never got a majority. The reason that they were able to have power was because of the system, which was constituencies. So you basically, if you voted for the opposition, the losing candidate in a constituency, your vote counted for nothing. So that's why it's very difficult to have smaller parties in Britain. It's very difficult to have independents. And the Liberal Democrats in the previous government in Britain, the Conservatives didn't have a majority of the seats. They had to form a coalition with the Liberal Democrats. The Liberal Democrats made this a condition for forming a coalition with the Conservatives, that there would be a referendum in Britain to see whether this system should be changed. And they got that referendum, and the British people didn't want to change it. So that's different systems, as it were. There's a similar situation, I suppose, in America where it is possible and has happened where the majority of voters don't necessarily elect the president. You usually get the president elected by the majority of voters, but because of the American system, you can have times when the majority of voters actually vote for the other one. So in the whole George Bush, Al Gore election, Gore got the majority of votes. But that's just different systems of democracy. But I think the British one is interesting because they didn't want to change it. They had the option. Anyway, that's our system. What it means then is that the party then allocates, you vote for the party publishes a list, which is the strict sort of requirements about the party being able to change the list. So it can't change the list for at least a year after the elections has taken place. And then the parties will allocate constituencies to members. Smaller parties will obviously, one-person party will have a constituency for the whole country. From the ANC side, there is generally outside the metros, more MPs to a metro, but outside the metros, one MP to a municipality. So that's sort of basically that. Then the executive come from the members of parliament, although there's provision in the constitution that the president may appoint 2 ministers and 2 deputy ministers maximum who are not members of the National Assembly. Otherwise everybody has to be a member of the National Assembly. The origins of that are quite interesting. It was in the term of Nelson Mandela's presidency. It was the government of national unity. There was a big fear around the economy from international capital in particular. And the Minister of Finance was I think, from the National Party, because in the government of national unity the seats were divided. And the Minister of Finance was from the National Party but wasn't particularly much of a politician. And anyway, he resigned, and then President Mandela wanted to bring in another person who was completely from the outside, white person, I think it was Chris Liebenberg. And he wasn't a member of the National Party, but it was to try and placate international capital. And that's when the constitution was changed to allow him to do that. Ironically, when the first black, and I use black in the context of black equals to in the South, Indian coloured African, when the first person of colour then was appointed as Minister of Finance, that was Trevor Manuel, the rand dropped hugely. But anyway, that's sort of that. The deputy ministers are members of the executive, but they're not members of cabinet. You're appointed by the president, so your minister doesn't generally have any say in who gets appointed as his or her deputies. And it can be quite a difficult role. The deputy is meant to deputize for the minister. In my case, I was appointed in 2013. So my first minister was Jeff Radebe. There were specific delegations that I was given, so specific powers that I exercised independent of him that the minister delegated to me. Things like appointment of acting magistrates, establishment of small claims courts and appointment of small claims court commissioners, appointment of sheriffs and acting sheriffs. Those were sort of specific powers. But then you would generally, most of government works by way of memoranda. So if there's an executive decision to be taken, a memorandum is prepared by the officials. And when the minister signs that, that's effectively the decision taken, and that's the record of the decision. Now, in the case of where I have delegations, when I sign it, that's the end of it, that's the executive decision. But with other matters, it would be the minister. Generally, in Minister Kadebe's time, most of those memoranda came through me first. In the case of the current minister, I've got the same delegations, and effectively he's wanting all the memoranda to go through me before they go to him. And then would obviously rely on my views quite heavily. Deputy minister, only when, if the minister is away, there has to be an acting minister. The acting minister has to be a member of cabinet. So the acting minister can't be the deputy minister. And it's a bit of an anomaly, but that's what's in the constitution. When justice has an acting minister, I quite often don't even know who that is. And the acting minister will not want to sign memoranda because they don't know what's going on either. So they'll get called on to sign if there's something urgent. I remember the one time I had to find out we needed a decision relating to some proclamation for the establishment of some courts. And the Minister of Justice was away. I had to then find out who's the acting minister. It was the Minister of Police. I then had to phone him to say, look, please will you sign this, because we need to publish, and yes, it's all above board. You know, it's not something contentious that the minister, when he comes back, is going to be unhappy with. So that's sort of basically that. So that's I think largely on the executive issues. I have a constituency. It's in KwaZulu-Natal. It's a place called Richmond, not Richmond in the Northern Cape. It's just outside Pietermaritzburg on the R56 as you go down to Kokstad, for those of you who know that area. And then you get allocated money by Parliament for a constituency office. You never see that money. That goes to the party. It gets audited though, so the party can't abuse it. That money is used to rent an office, to employ an administrator. And then obviously I have less time as Deputy Minister to get there, but you attend to all range of issues in your constituency and have people contacting you about a variety of problems and things. If you have a reputation for being a lawyer, then sometimes people will contact you about their legal problems. So this morning some guy he phoned me before about a car that he bought, and it was new, and it was a problem with the it was defective, but the company wouldn't see it as defective, and what should he do? So I gave him some advice, and then he phones me this morning to say no, the company had agreed without fault to repair the car, but now they've repaired it and the clutch is still smelling. So those are the kinds of things that one gets. So that's that. Just with policy issues, because I don't think you've got anyone apart from Ronnie Casserol's. I don't think you've got anyone who's been. And Ronnie was only very, very, very briefly an ordinary MP. He got made a deputy minister very soon after '94. But basically, from government side, policy is the prerogative of the executive, as it were. In general, more, and this is probably not going to be that academically correct, but it's more an expression of what happens practically. There's meant to be sort of formal policy for different aspects. To develop that policy, there will often be a public participatory process, which will involve the drafting of a green paper. A green paper is basically setting out the questions that the policy needs to address. There'll be a public participatory process over that. Then there will be a white paper, or a draft white paper, and the white paper is the policy, so it's the draft policy to begin with. That gets put out for comment, and then when it's adopted, it becomes a white paper, and that is the official policy. That process is run by the executive, so it would be cabinet that would approve a white paper, not Parliament. Sometimes Parliament can be invited to be involved in the discussions. Any legislation that then, the policy doesn't actually implement anything. So arising from the white paper would then have to be legislation. And again, most legislation comes from the executive, although there is provision in our constitution for private members' bills and for Parliament to initiate legislation. When it comes to the drafting of legislation from the executive, usually there will be a public participatory process. If it's a complex issue, a bill will be put out for public comment. The department will receive that comment, amend the bill, and then ultimately, before a bill goes to Parliament from the executive, it has to be approved by Cabinet. So a bill is not the bill of an individual minister, it's the bill of Cabinet. So just to be sort of technical, usually if it's a contentious matter, the bill will go to Cabinet for approval to be distributed for public comment. Then after the public comment, we'll go back to Cabinet for approval to be introduced into Parliament. The reason why Cabinet is sort of wanting to see the draft bills out for public comment is that the draft bill would reflect on government as a whole. So there were complaints in the past where something was pretty controversial and ministers would complain they didn't know anything about it. Just a quickie on the Cabinet system. There is Cabinet, which is then the official decision-making structure of the executive. That is only ministers. In the time of President Mbeki, deputy ministers also attended Cabinet, but the view then was under President Zuma to follow what was in the Constitution. You then have Cabinet committees, and there are 6 of them, and they're divided into thematic areas. And on those, both ministers and deputy ministers sit. So generally, most stuff going before Cabinet would go, almost all stuff going before Cabinet would go to a Cabinet committee first. And then if approved by that Cabinet committee, would go to Cabinet. Usually it wouldn't get rediscussed. Cabinet would simply approve the minutes of that Cabinet committee meeting. So if it's a draft bill, for example, it'll get discussed by the relevant Cabinet committee, and then Cabinet's approval of it would be effectively by approving the minutes, although other ministers who are members of that Cabinet committee could say, no, they've got a problem and want to rediscuss the matter. But anyway, that's sort of that. So yeah, then the bill gets introduced to Parliament. There is a constitutional requirement for public participation in the legislative process. So a bill would be advertised for public comment. If necessary, there would be public hearings. There is provision for bills to be speeded up, but it does take quite a long time to pass a bill. Obviously, if there's no interest, I mean, the sort of landmark case for those of you that have done law courses is the Doctors for Life case, where Doctors for Life challenged a bill amending the Termination of Pregnancy Act, and they challenged it on the basis that the Second House, the National Council of Provinces, had promised hearings, I think, in Gauteng and didn't have them. And Doctors for Life had wanted to attend those public hearings that were promised in Gauteng. And the court said on that basis Parliament hadn't followed the correct procedure, it was unconstitutional, and the bill must be redone. There was another bill which was also challenged at the same time called the Dental Technicians Amendment Bill. And with that bill, nobody, and no disrespect to any of you that have studied dentistry or have any dental technicians, but nobody expressed any interest in commenting on that bill. So although the Gauteng legislature had promised hearings on the dental technicians bill as well, because nobody had indicated any interest in having a hearing on that bill, the Constitutional Court said, okay, it's fine, because there wasn't any interest, that bill could go through. So yeah, so that's sort of largely that. I mean, I can talk to you a bit about some of the bills. I mean, I was on the, as you heard from the introduction, on the Justice Committee for a long time, and you heard some of the bills which you may know about. The Child Justice Act was sort of quite big, the protection of personal information, but all some of the bills that are coming at the moment. We have a bill on hate crimes and hate speech, which is about to go to Cabinet for publication for public comment. We have a bill on cyber crimes, which has been out for public comment and generated some controversy. So you may want to sort of me to speak a bit about that, but actually, Aslam, you did say 15 minutes. I said it would be shorter. I've taken 15 minutes now, so I think let me stop here and hear what areas of interest you've got. I don't know how you do your questions, whether you want one question, one answer, or whether you want a few. The problem with the few is that sometimes people raise different topics, so it may be better one question, one answer, unless maybe this, and it depends on how you do it. One question, and then if anybody else has got any similar questions related to that one, that they then ask it, but not on a different topic, and then one goes to the next topic.
Yeah, that sounds good.
Okay.
It's up to you.
Sure. So, I don't know what basis to start. You did actually have your hand up, I think, first.
Yes, as the Deputy Minister of Justice and Constitutional Development, can you please explain to us the Office of the Public Protector and its powers?
Okay. Any more questions on the Public Protector? Dead silence.
Just want to hear your views, because I remember recently, I was reading a watch, and I remember recently you made a comment that their findings were not legally binding, you know. If you also could comment on that.
Yeah. Look, I mean, that's been the fundamental issue. The public protectors in the Constitution under Chapter 9. Chapter 9 is about institutions supporting constitutional democracy. And it's the Public Protector and Human Rights Commission, the Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, the Gender Commission, or what's formerly called the Commission for Gender Equality, the Auditor General, the Electoral Commission, and the Independent Authority to Regulate Broadcasting, which is quite interesting in the sense of it doesn't exist anymore, because and it's an indication of how constitutions can fall behind technology. So in 1996, when the Constitution was being drafted, you didn't have really, you had cell phones, but you had the internet, but electronic communications was quite different. So the broadcasting was really just about TV and radio, but it's become, what is it now? ICASA, yeah. So it's Independent Communication Authority of South Africa. So that's effectively, the successor of this. Look, the debate is interesting, and it was clarified by the Constitutional Court on Thursday about whether the Public Protector's powers are binding or not, and the Constitutional Court, by unanimous judgment, felt that they were. I suppose a provision really is that the Constitution refers to the Public Protector having the power to take remedial action. The Public Protector is an ombudsman, and I think there's general acceptance of that, particularly when the Constitution was certified by the Constitutional Court. Generally, the role of ombudsmen are to have a quick investigation into a matter, come up with some kind of finding, and put it into the public domain. And that's what happens across the rest of the world. So no ombudsman anywhere else has got the power to actually, or none of their decisions are enforceable. The view in South Africa was generally there was actually consensus before the current Public Protector and I think the Nkandla issue that it was similar here. So you would have in some textbooks that South African law textbooks that the decisions are not binding, or the remedial action is not binding. You had the first Public Protector, Selby Bakwa, saying that the decisions are not binding. You had the Public Protector herself saying, "Oh no, it's working because government implements 92% of the remedial action." So obviously, if they weren't implementing 8%, then why wasn't she doing anything about it? So that's basically the issue. The High Court in the Western Cape found that they were not binding, but they couldn't be disregarded. There needed to be a rational basis for disregarding. The Constitutional Court has found that they then are binding. My concern with that is that You know, I attended a heads of court meeting yesterday. I joked with the judge president of the Labour Court that now we can actually reduce his budget substantially, because any public servant who gets dismissed doesn't have to go to the CCMA, the Public Service Commission, or to the Labour Court. They can just go to the Public Protector. And the problem with the Public Protector is that there's no appeal from the Public Protector's decision. You can take the Public Protector's findings and remedial action on review, but you can't appeal it. And for those of you who are not lawyers, appeal is basically, here's the set of facts, would you make a different opinion on the facts that were put before the lower court? Review is about procedure. Did they have the power? Were the correct procedures followed? So it's not about the facts. And you know, that's of concern. So it's issues like that. So are you
saying that the decision has opened up a can of worms, essentially?
I am concerned about what the impact is going to be, because I would say if you were a public servant and you got dismissed, just go to the Public Protector. Okay? Public Protector investigates anything to do with the state, so that's why you have to be a public servant. If a police vehicle, and the issues that what they do, they investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice. So that's very wide. I think it needs to be wide to give them a wide ambit. The only restrictions are that they cannot, and it's in legislation, they cannot investigate court decisions. So, you know, if you have a car and a police vehicle crashes into it, then if you feel that conduct is improper, which I'm sure it would be, then don't worry about suing the Minister of Police. Just go to the Public Protector. That's my worry about the can of worms. You know, a lot depends on how the powers are interpreted, but I think there is a reason why no other ombud in the world has those powers. And then similarly, if you look at the other Chapter 9s, the Human Rights Commission can make a finding against you that you've violated somebody's rights. That finding doesn't mean anything. It's put into the public domain. Obviously, if somebody finds that I violated somebody's rights, I'm not going to be very happy about it. I'm going to probably do something about it. I'm probably going to get attacked on Twitter or something like that. But the Human Rights Commission's powers, or if they want to have it enforced, they've got to go to court, usually to an equality court. The same would apply to the Cultural Linguistics Commission, the Gender Equality Commission. The Auditor General has to have their powers basically approved by Parliament, so if they find unauthorised expenditure, it goes to the National Assembly. And then the Electoral Commission do have powers that they can make decisions that are binding. But then you have a specific electoral court and an electoral appeal court set up to hear applications against those decisions. So that's sort of basically it. In some jurisdictions, Sweden, for example, the Public Protector has the power to prosecute. So look, it's new. This, you know, to be fair to the president as far as the whole furor over should he resign, has he violated his oath of office, the position was not clear before the Constitutional Court judgment. There were a range of debates and issues. The Constitutional Court has taken a decision. They're the ultimate authority on the Constitution, so that is the decision. We've then got to see how, obviously, if the state is unhappy with a decision, they can take the Public Protector on review, but there is the problem of review is more limited than appeal. So I think there's a lot of thought and there's going to be a lot of litigation to work out how is this going to work in practice. So you've got the decision that yes, the remedial action is binding. How that's going to work, it's going to probably take quite a few court cases to resolve how that's going to work. Also on Public Protector.
No, it's not.
Okay, can we finish Public Protector then? I would I don't want to be here the whole time talking on public protector, but okay. Last one then on public protector.
I'm sorry. I have sentiments that you have. There's an implication of the president from the last statement that we've done. I was watching Maimani's interview. I think there's a clause in the Constitution. I don't know if it's Section 28. I just missed the number.
It's 89. I think.
89.
Yeah.
Yeah, something like that, where it says if the president has violated the Constitution, if he's not removed from his position, then the Constitution won't exist anymore. Something like that.
I hope you heard it wrong. Look, the provision, and there is a motion in the National Assembly tomorrow afternoon, it's in the latter part of the afternoon, which is that the National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the President from office only on the grounds of 1, a serious violation of the Constitution or the law, serious misconduct, inability to perform the functions of office. So it's that he's speaking about, and it's that's going to be deliberated on by the National Assembly tomorrow afternoon. The consequences are that then the person removed doesn't receive benefits of the office and may not serve in any public office. There's another provision in the Constitution, which is the motion of no confidence, where if the National Assembly loses confidence in the President or Cabinet, then by a simple majority vote, they can vote to remove the President, and there's no consequences in terms of the President's pension and so on. But this one then is around, the question for tomorrow is, should the National Assembly remove the President, or has the President committed a serious violation of the Constitution or the law, and if so, should he then be removed? If the National Assembly, I'm going to be speaking in it. I'm going to be arguing that it's not that, well, to some extent what I've said here, but you could listen to it. But if the National Assembly votes not to remove the President, and as it's a 2/3 majority is required, it's unlikely, then the Constitution is still there. You know, so that's why I'm saying in terms of, I would hope you heard Musi Maimane wrongly. Yeah, because the issue basically against the President is, well, the Constitutional Court didn't find that he'd seriously violated the Constitution. They were asked by the EFF to rule on that. They declined to rule on that. They found that he had violated the Constitution in terms of not taking the Public Protector's report on review. That was the gist of the issue. But at the time of that, as I said, there was legal confusion as to whether that was necessary or not. And in fact, at one point, the law as it was in terms of the Cape High Court decision was that he didn't have to take it on review. There needed to be a rational basis. And the Constitutional Court also said that they accepted it. He may have acted in good faith, so they weren't saying he acted in bad faith. So anyway, you could let's if we can leave that for now and you listen to the debate tomorrow. You had a different issue.
Yeah.
I hope.
I actually have 3 small questions.
Okay.
The first question is the ministry committed to improving conviction and rehabilitation of rapists? And since the conviction rates are so low, because due to a number of reasons, which include the fact that a lot of rape survivors feel like they're the ones who are actually on trial. And secondly, if a trans woman is convicted of a crime, which jail will she be in? And third question, what rehabilitation measures do you have in place to rehabilitate those who are convicted so that when they are released, they can be integrated into society, because we don't create hardened criminals?
Sure.
And also, your answer on the second, can you also explain why on the second question?
Okay, just remind me if I've forgotten something. But is this also on sexual offences or crime?
For me?
Yes.
No.
Okay, I thought you had your hand up again. Obviously, we want a situation where anyone who commits a crime in South Africa gets gets tried for that crime and gets found guilty of that crime if they did it. Remember that our legal system is, for those of you that haven't done law, our legal system is weighed in favor of the accused. In that the court has to, in deciding if somebody is guilty of a crime, they've got to decide that beyond any reasonable doubt that the person is guilty. So they can think the person is guilty, but they can't discount their defense by saying they can think it's unlikely, but it's possible. They must find the person not guilty. In a civil matter, that's a dispute between citizens. I mean, not between citizens, between individuals. There, the court decides on a much easier standard, which is balance of probabilities. So in a civil matter, if this is like a scale, if the scale tips slightly that way, then the court will decide for the right hand. In a criminal matter, it's like this. The court has got to decide there's no reasonable doubt that the person is guilty. So you can find situations where a person is found not guilty and loses a civil case because of that different onus. And that's sort of, there's the story of, I think it's an English adage of it's better for 9 guilty people to go free than for 1 guilty person to be, 9 guilty people to go free than for 1 innocent person to sit in jail. So that's what it's aimed at. So it is weighed in favor of the guilty person, and there are those reasons, and one can have a longer debate over it. Obviously, we're committed to improving the conviction rate. There are targets generally for the different levels of courts. The investigation gets done by the police. Then it goes to, there's guidance usually from the prosecutor. The prosecutor runs that case. There is that separation which we lost with the Scorpions, where you had the prosecutors and the police together in the same unit. But if that happens, the problem is once you're involved in a case, once you're investigating it, you lose your objectivity. You think the person is guilty and you want to get them. And you can look at cutting some corners to make sure that you've got more evidence against that person. So the separation between the prosecution and the police is important. On the issue of sexual offences, I mean, yes, the conviction rate is low. What we've been doing to try and improve it is one, the establishment of the Tutuzela care centres, which are specific centres attached to clinics whereby if you get attacked sexually, raped or otherwise, that you can, while you go for treatment, you also have evidence collected from you. Semen, whatever, statements taken from sympathetic people and so on. So there are those centres. We don't have enough, and they are attached to clinics. We don't have enough. I think we need to look more at what can we ensure that every clinic has a basic provision for people who are going to go on to lay charges against the person. Then we've been rolling out sexual offences courts. Most of the sexual offences get dealt with at a regional level, so they're regional courts. And they are special courts where the complainant, the survivor, victim, whatever, doesn't have to sit in the same courtroom as the accused. There's basically video TV, closed circuit TV, where so they testify there. They can testify with an intermediary to assist them. If it's a child, that becomes particularly important. There's separate entrances for the complainant, the survivor, and the accused, and so on. So we are trying in that way to, those are some of the ways to improve it. We do have a special prosecution unit, sexual offences, SOCA, sexual offences and children, I think it is. I think they deal with that together. So yeah, we are trying. We need to do more. But it's a difficult terrain. And I think the key thing is also with the sexual offences courts, my worry is how sustainable is it? We do also then have minimum sentences, or that's where it started, was with sexual offences, where you had problems where the presiding officer might have a particular attitude to women and the way they dressed, and therefore they should get a light sentence. In spite of that, I mean, and that any minimum sentence, you can't take away the discretion of the court. So if there's, compelling reasons or substantial and compelling reasons, the court can deviate. You still have a few odd sentences on sexual offences coming out of, like, a guy rapes a 12-year-old and because she was family, it's not so bad, or something like that. I can't remember the case exactly. Some of you may know it, but you still have some odd ones in spite of that. So yes, we are trying. We need to look at doing more. The issue then about intersex persons and jail, I really don't know the answer. I imagine obviously that there would probably have to be special arrangements made for them. I don't know if any intersex people have been sentenced to imprisonment, but it's something that they would have to raise in court when it comes to sentencing. The issue is that the court first of all looks at is the person guilty, and then once it's decided whether they're guilty, then it looks at the issue of sentence as a separate inquiry. It doesn't sort of do the two together. Then rehabilitation, yes, that's a big issue. We particularly emphasized rehabilitation with children, so the Child Justice Act that you heard about was a special dispensation for children in trouble with the law, child being a person under the age of 18. So the first thing is basically that trying to keep them out of jail even when they're in custody. First appearance is what's called a preliminary inquiry. Before that, social work has to look at their circumstances, and then trying to divert as many of those cases as possible. So instead of sending them through the criminal justice system, sending them on programs to try and correct them. Problem obviously is the overcrowding, which makes rehabilitation more difficult, but there are a number of programs going on in prison. I think let me leave it like that. Link to this or new?
No,
Anyone more on this point? Okay, I'll give you, because you haven't spoken before, then I'll come to the lady in white.
I know you recently had the annual general meeting on hate crimes, and so I wanted to know, with particular focus on the LGBTQI and foreign national attacks, what was the outcome on that?
Okay, so Lebo, yours was that linked to the previous question, or was it a new issue? Okay, do you want to discuss it?
I wanted to ask about whether the Zella care centers are also open to victims that are already incarcerated, and is there?
Sorry, how can a victim be incarcerated?
Okay, so basically the rape stats, particularly within male prisons.
Okay.
Yes.
Yeah.
Are the Zella care centers open to them? And is there a way of dealing with rape issues that happen within the prison? Within prisons, even though of course it would be taboo essentially, because that environment sort of creates a space where should anything happen to you, particularly of a sexual nature, you don't rat the person out, because then you create a hostile environment for you to exist in within the prison system. So is there anything that the ministry is doing, particularly to address the rape stats in male prisons?
Okay, just maybe a disclaimer to begin with. The minister is the Minister of Justice and Correctional Services. He then has two deputies. One is a deputy for Justice and Constitutional Development, and that's me. And then there's another one for Correctional Services. So I'm not directly involved with them, but anyway, I'll try. On the issue of the hate crimes working group, look, that was about, and you presumably would have read my input, and that was about, there's been pressure for some time for legislation on hate crimes. And from a policy point of view, it's actually quite interesting. We originally, I found it near the end of the policy process when I was appointed. Originally, the Department of Justice wanted to do a policy, and that policy went to Cabinet for approval for public comment. It was just before the 2014 elections, and Cabinet felt, it was Cabinet Committee, felt that, look, it's not a good time to debate these issues. The countries already would be divided over different policy issues. It's not a good time to start debating a policy on hate crimes. So rather hold it back until after the elections. So then with the new minister, both he and I felt, look, do we actually need to have the policy first? Why don't we just come up with a bill? And that was then the direction that we were going on. So we in fact then decided not to go the policy route. Originally we did not want to include hate speech as a hate crime because, hey, as South Africans, we're pretty divided. There was an example of there's a lot of divisions around whether what you say is hate speech or not. A hate crime is basically an existing crime where the motive in whole or in part is because of the identity of the person, and you don't like that identity. One of the interesting issues is there is in the bill a list, and I don't think it was there is a list of categories. Those categories were taken from the Constitution and from the Promotion of Equality Act. But not all those categories are in the hate crimes bill at this stage. For example, you can't discriminate against somebody on the basis of being aged, old. You can't discriminate against a woman for being pregnant. But to my mind, those are not categories that you should have as hate crime, because you're unlikely to find any person going around attacking pregnant women just because they're pregnant, or attacking old people just because they're old generally. You might find a person attacking a pregnant woman because he doesn't want her to have the baby because she's his ex and he's so jealous, or it's the boyfriend, the father of the child's ex, but it would be specific to that person, so it's not as a result of her membership of that category. You might kill off your grandmother because you can't wait for her to die and so you can get the inheritance, or you're tired of looking after her, but again, that's not because of a category of old people. It's a specific thing against that person. So there's that. Hate speech then is in the Constitution is sort of limited in the freedom of expression section. The limitation has to be because the speech causes harm. Now, obviously, the key question is going to be what is harm? Is harm it cause or could cause harm? And if somebody is racially insulting, you've suffered harm. I mean, we'll probably try and push the bounds to that level. We've included hate speech more just because, I think the last few months have shown that we have a particular problem in South Africa. There is already a remedy for hate speech in terms of the equality courts, which is a civil court, but we do need to actually show that this kind of offensive speech is not acceptable. But going back to the definition of hate crime, if you throw a brick at a mosque, you will be currently charged with malicious injury to property, which is a relatively minor matter. If it can be shown that the reason you threw the brick at the mosque was because you don't like Muslims, then it becomes a hate crime. So it's the same. You beat up somebody, assault them, it's assault. You assault them because they're gay or because you think they're gay, then that's a hate crime. So that's how it works. And then, what was yours now? Oh, the prisoners. Okay, I did the disclaimer for you. Look, I don't know the programs. I mean, one of the key things relating to juveniles or to children was to, particularly because of the high incidence of sexual abuse in prison, to keep them out of prison, and we have substantially dropped the prison population of children. So I think it was about 700, and I think we're down to about 100 now. The intention is for them to go to secure care facilities. No, obviously you'd have to walk in, you'd have to get to a Tutuzela care center, so you would not, a prisoner would not be able to get to one. However, you're already in a state institution, so in theory and hopefully, if you say you've been raped, then you would be taken to the prison clinic and tests done for semen samples and so on. But I can't, yes, I'm sure it is a problem of rape in prisons. There are programs, but I can't give much more detail, or don't know much more detail on them. Okay. 15 minutes, I can go on a bit longer, but I think you've got other programs on the go. The lady at the back in the, what's it? Tori.
So I wanted to know on creating public policy, your current process of consulting with the public, do you think it's effective given the pension fund regulation that it has not been backchecked, and famously the e-toll issue? Do you think perhaps the current form of consulting would narrow perhaps?
Okay, anyone else with questions on public consultation? Yep.
Yeah, so in local, I think I'll speak from a planning perspective, so there's consultation in that aspect as well. But it's a lot of the consultative process kind of goes through a political filter, and the things that can be delivered are then promised, and the things that can't really, or not onto the program, kind of get filtered out and pushed to the side or dealt with really meaninglessly.
Okay.
And on that process, who are the public that you consult? Who are they?
Okay, look, I think those are good examples and Aslam, from what you're also saying. Let's take, we have, a broader question. We have decentralized, this government post-94 has decentralized power and tried to empower people. So you have empowerment at a schools level with school governing bodies and schools having power to take decisions, those SGBs. You've got statutory community police fora around each police station to discuss crime. At a local government level, you've got statutory, and for the non-lawyers, by statutory I mean it's in law, you've got ward committees. So you're not just voting for your councillor, the ward councillor has to set up a ward committee to try and involve more people. So there are these efforts. Those are the statutory ones. There are then other ones as well. There's also a requirement at local government level that there has to be an integrated development plan, and each ward councillor must take that plan to their ward, to a community meeting every year. It gets revised every year. Are those working? No, they're not working to the extent that they should. Why? Well, hopefully you guys will some of you look at that or debate in this week those questions. Maybe it's that things are boring. So you go to an IDP ward meeting and you'll have an official from the municipality. Now, Assam, it's meant to be like a program for a number of years. So they're meant to say, look, we can give you this year, but this other issue we can only give you later, in 5 years' time. So the issues coming up there would be, we want the road tarred. That's expensive, so maybe that'll take 4 or 5 years. Some of the issues would be subject to other requirements. So a common request or demand from a community would be, we want a clinic. But from the Department of Health side, you've got to have a particular number of people to have a clinic. So not every community can have a clinic. Some will have mobile clinics. And you're not going to get a clinic if you don't have the numbers to justify it, because otherwise it's a waste of money. But why is the process not working? It's a good question. Maybe it's a question of empowerment. But is it not also an issue of, from my time in public office, people generally tend to not be particularly interested, carry on with their own things, and it's only when things go wrong that they then start getting interested. So with the e-tolls, look, I wasn't particularly involved in it, but my understanding is they did advertise. They did ask for comment around, should we pay for these roads by e-tolling, and nobody did anything. The South Africans, one thing I do know, we always leave everything to the last minute. So if you have a deadline of you must get your driver's license by this date, generally it will have to be extended. You'll know the IEC doesn't like saying, the IEC, Usually before any election, they'll have 2 voter registration sessions. If you look at them, they don't like saying, during the first voter registration session, they don't like saying there will be another one. Because if they're worried if they do that, then they think people will just leave it to the next one, and then they won't register at all. So yeah, I think those are interesting questions. In terms of public participation, it would depend on the nature of the issue. So when it comes to legislation, we've got a bill coming on international arbitration. We're not putting that out for public comment as the department. We've consulted the key stakeholders involved in international arbitration. We didn't feel it was necessary. Obviously, when it goes to Parliament, Parliament has to advertise for everybody. Anyone can come. Anyone can make a submission. And then there would only be hearings if somebody says, I'd like to be heard. And Parliament feels that it's relevant. I doubt if there'll be public hearings on international arbitration. When it comes to hate crimes, as I said, we are putting that out for public comment. It will be advertised in the media. It will be advertised online. We have been working with the Hate Crimes Working Group on that. So they have, for example, seen the draft. One of the thorny issues in the bill, to the person who asked the question before, is do you provide for restorative justice in the hate crimes bill? And it was originally in the bill. In the discussion with the working group, there was a lot of debate and division, and for the moment it's out of the bill. So we had stakeholder engagement first, then we'll go broadly to the public, then when it goes to Parliament, Parliament has to be the whole public. But you do have problems in terms of, when I was in the KwaZulu-Natal legislature, look, it was easier because it's a province. And so you have public hearings on a bill. Now your average person is not going to know much about a bill. And the thing you find is that when you have hearings at a central level, it will be educated people, organized people, civil society groups who've got a particular interest. And you don't hear from ordinary people. So what we would do in KZN was when we'd have hearings, we'd go sort of around the province to different centers. And we'd use those hearings actually to explain the bill, to an ordinary person. This is what the bill is about, what do you think of that, what do you think of this, and that was quite effective. That's more difficult for Parliament to do because it's the whole country. So yeah, that's just that. More on
yeah, so just on the issue of the consultative, or what is supposed to be consultative. So especially when the Constitution talks about education, because that essentially is a public policy. And do you think that the people who are consulted before something is drafted into the country or made into a law or legislation, do you think that the people who are consulted have an impact on the quality of that particular legislation? Because if you look at the right to education, it doesn't really facilitate substantive equality, because it just says you have a right to education. It doesn't really address what kind of education you're getting. It doesn't really qualify that right of education. It's not limited to having access to a school, but it's also including the proper infrastructure, having qualified teachers, not being taught under a tree, not having textbooks for 2 to 3 months into the year. So do you think that the kind of people that we consult affect the quality of delivery?
The person.
And another, I don't know if this is a suggestion, but we have huge problems with unemployment. I'm very passionate about youth empowerment in South Africa. If you're saying that Parliament doesn't essentially have time to do these consultative processes that you did in KZN, why not employ dropouts or students that can't get into tertiary institutions? Why are the Parliament or the South African government not using their resources properly and use these people who live in the communities to communicate the bills and get the information to you guys that you actually need?
But my question is on the Constitution itself.
Okay, can we come back? Yeah. Look, when Parliament consults, it really does need to be the MPs. So yes, research does get used, and what you're talking about of sort of unemployed people, unemployed graduates. But I think the fear would be that if they get the thing wrong and explain the wrong processes, it can be worse. Yeah. Look, it's something. I think it's an important issue to debate. Definitely, look, there are different views depending on where you come from. So the Legal Practice Bill Act now on the attorney's profession was very controversial because there were huge divisions between attorneys and advocates. So it doesn't mean that everybody's going to be saying the same thing when it comes to consultation. And ultimately, you've got to make a policy decision around which way you go. The courts have said, can't remember a specific one, but that the requirement with public consultation is that you must listen. You don't have to agree. And definitely we all come from different interests. I mean, the issue, for example, and maybe hopefully not go into areas I shouldn't, but Kolobeni mining on the Wild Coast. Which has resulted in the community leader being murdered, and the debate is, and I've never been to Kolobeni, but I would imagine that the dispute there is that do you have, because we had it at St. Lucia in KZN, do you mine and hopefully then generate job opportunities from that mining exercise, or do you keep it as it is for tourism? And that was the whole debate with Lake St. Lucia. Should there be mining, same thing as Kolobeni for titanium, in St. Lucia, or should it be a World Heritage Site? And eventually the decision was one way or the other. E-tolls would be who pays for those roads. Should it be people in Gauteng through the pay as you user pays issue, or should it be the whole country? And you're going to have different views. So that's the difficulty with the public participatory process. Generally, what I found with when I was in Parliament with the legislation that I was involved in, that it helped. Sometimes Parliament will have the public participatory process, and people make submissions. People come and make oral submissions as well, and then it's closed, and then you deliberate on the bill. What I had found is it's easier actually working, particularly where you've got specific civil society organizations who've got expertise. It's easier working with them on a more regular basis. So when we worked on the Child Justice Bill, we then got 2 or 3 people or invited the NGOs to give us 2 reps. And we then took a consultant as well to help us work through the bill as we went through. Protection of personal information bill, a lot of contentious issues. So, people were welcome to make submissions the whole time, and you're balancing different rights, so it becomes more difficult, the right to privacy, and you don't want to upset journalistic freedom. And so it does help to continue the engagement. But I think with the public participatory process, yes, it should be everybody who wants to be heard, but then often people don't want to say anything until they realize what it actually entails, and I think that's what happened with e-tolling. And you've also got to have huge disputes often, and you've got to try and work out how to balance it. And then you may also have a policy position as a party to say, look, this is what we are doing. Let's take labor broking. Okay, very popular political issue of ban labor broking. But I think what has then happened from government's perspective and from Parliament's perspective is that it's a bit more complicated than that. So you want to very much regulate it, you very much want to restrict it, but you can't actually ban it outright. Policy decision being taken, going to be taken quite soon on should there be a minimum wage. Debates around will that reduce employment, but will it, people are being exploited. So there are all those kinds of different issues. And I think the thing you've got to accept is that the people who shout the loudest are not necessarily right or necessarily the majority. But Abu Bakr, sorry, I'll come to you then.
My question is most on the notion of the Constitution. Most of the people, they feel that the Constitution advocates for peace other than justice, because when it comes to the issue of land, the Constitution doesn't address that particular issue in an appropriate manner. So since you're working in that department, so what do you think? Because I also share the sentiments that the Constitution doesn't advocate for justice, and why not the Freedom Charter instead of the Constitution?
Look, the Constitution was a product of a political settlement. There was no defeat of the apartheid regime. They saw that they could have carried on. Obviously not for particularly long, but they could have carried on for quite a bit longer. They saw that they needed to settle. I think they hoped, I don't think they expected the settlement they got. They expected a better settlement from their side. But you've got to see it as the Constitution was the product of a political settlement. The different parties negotiated an interim constitution. There was no way of knowing who had what support. So you had this thing of sufficient consensus, which effectively was if the ANC and the National Party agreed, then there was sufficient consensus. So both the National Party had a veto effectively, as did the ANC. The interim constitution had at the back a set of constitutional principles. I mean, it was part of the agreement. Part of the thing that the National Party was afraid of was that, okay, we agree on this interim constitution, but then when Parliament is elected to draft a new constitution, how do we make sure they're not going to completely overturn what we had agreed to when we agreed to give up power? So in order to compensate for that, there was agreement that there would be a set of constitutional principles at the back of the interim constitution, and the new constitution needed to conform to those constitutional principles. So after the constitution was adopted by Parliament, it had to go to the Constitutional Court to see if it did conform, and there were a couple of points where the Constitutional Court said it didn't, and those had to be changed. So yes, the Constitution is about a political settlement, not about justice. It was about peace. So yes, that's the historical context of it. I think while you're talking about peace and justice, just also to say, because of the Al Bashir issue has been in the news, the International Criminal Court, that we opted for peace, not justice. In that one of the sweeteners to give up power to the National Party regime was some kind of amnesty provision. That if there was a dispute over it, the National Party wanted a blanket amnesty. The ANC was only prepared to give amnesty for specific events if disclosure was made. But the TRC would not have been allowed under the Rome Statute, because the Rome Statute that sets up the International Criminal Court specifically says that a country can't give immunity to anyone. That's when the International Criminal Court has jurisdiction. So that's sort of just interesting. I mean, that was our settlement was just before the Rome Statute came into effect. Why are you therefore pulling? You've been speaking too long, and I've got other people, but you're putting faces, so you must. No, it's an interesting point to think about. But this person here has just had, lady here has just had her hand up, and then Aslam, am I restricted to the? You're doing the timekeeping, so.
Okay, I'll just check now.
Okay, all right.
Thank you very much. Well, I think part of my question has been answered through his question, but I would like you to guide me in terms of minority groups in South Africa. How far or to what extent does the Constitution recognize them? In particularly, I would like to, I'm a Muslim, I would like to say on the issue of Muslim personal law, what does the Constitution say about it, or how far the issue around that has gone with the Constitution and the Muslims involved?
Okay. Look, we are different. I would like to put it this way: different to, for example, America or many European countries, where there's a general conformity So, in France, the courts have ruled that you can't wear a burqa at school. In South Africa, we emphasize our differences. So, the preamble is where was it now? Here we are. Believe that South Africa belongs to all who live united in our diversity. So we accept the diversity. Basically, there would be then within the Bill of Rights sections allowing you freedom of identity, group identity, freedom of religion, whatever. The key issue, but generally everything has to be consistent with the Constitution. On Muslim personal law, the issue has come up of Muslim marriages, and the problem where imams marry people, imams who are not marriage officers marry people, and the legal then recognition of those marriages. There have been cases where the courts have said, and the courts and government are concerned about the situation, whereby the women in the marriage can be extremely badly treated. From government side, and it's interesting on the policy aspect, we have been trying to do a Muslim marriages bill for some time. Where we have got stuck is that an engagement with stakeholders, we've engaged with, I think it was also a bit before my time, the Muslim Judicial Council. Because the conflicting rights are basically the right of a person to follow their religion and the state not to interfere in that. But then you've got the basic rights of people. So the problem with the Muslim Marriages Bill was that the Muslim Judicial Council would agree on the content of the bill, provided that Muslim judges would adjudicate on divorces of Muslim couples. Now, that position was anathema to cabinet. We're a diverse, multicultural society. The moment you say that if you've got a customary law issue, and let's say it's a Tsonga customary law issue, and only a Tsonga judge or judges can adjudicate on this, we're going down a very slippery slope. So that's where the Muslim Marriages Act got stuck over that point. There is litigation in the Western Cape Court over the issue, and we're hoping that court will give us some guidance. Personally, one of my other problems with the bill is that it defines Sharia concepts. Now, I don't think it's appropriate for, what is in the Quran, what is in the Bible is up to Muslims and Christians. And it's not for the state to say, this is what this Sharia concept means. So, my own view is that it would be better if we had a sort of generic religious marriages bill, which provides, so effectively, whether you get married, whether you get divorced, is up to the religion. But if you do get married, this is what it means. If you do get divorced, this is what it means. What we have been trying to do in the interim as government is to encourage imams to register as marriage officers. And so there has been a program with that, and a number have been on the course. And I hope the number of Muslim marriages that are then conducted by imams who are marriage officers would be increasing. One of the aspects that's there as well is to promote an anti-nuptial contract between the parties. So there are those, but we still do have to grasp the nettle around what to do. But it's a difficult policy decision. And what does not help it, and I'm not Muslim, but what doesn't help it is that from where I'm standing, it would seem as though there isn't consensus amongst the Muslim community. And then what do we do as government? And for my involvement, what do I do as a non-Muslim? You know, if the Muslim community were able to come to us and say, we've reached agreement on this is the regime we want, and it seems fair in terms of human rights, we'll pass it tomorrow. The difficulty with the bill has been the community itself can't tell us, and in those situations, from taking policy decisions, you end up getting stuck because you don't want to grasp the nettle, and then when you do, and we will eventually, and we may be forced by the court, you'll see sections of the community, I'm sure, will not be happy with us.
We can do another 6 minutes.
6 minutes, okay. Who hasn't asked questions? The guy at the back there.
My question is not directed to you as a DM, but as a lawyer. I just want to know, what if I work in a company, right, and this company shuts down before they pay us? Then what do we do, we as employers of that particular company?
This has happened to you?
It's happening to a friend of mine.
Well, look, they should go to I mean, it sounds as though it would not be legal. They should go to the CCMA, probably go to Department of Labour for assistance, depending on how much they're earning, or go to an advice office, or I mean, depending on how much they go to a lawyer if they're earning enough. If they're not earning enough, then go to an advice office, go to legal aid, or go directly to the Department of Labour offices and have the case taken up at the CCMA and ultimately the Labour Court. But they need to move fast, because also if the company shuts down and then, you know, if there's a court decision made in their favour but the money's already gone, it becomes more difficult. So they need to move fast. Okay, who hasn't asked? Guy in the red, and then you. That's the last two then.
Okay, thank you very much.
You asked already, sorry.
I would like to pose a question in particular with regard to the practices of religion. We've recently, not in the distance past, seen a religious organization like in the news where people are drinking petrol and eating grass and all those kind of things. So I want to, what is the role of you as an institution? How can you mitigate for that? Because people's lives, even though you don't want to interfere with the practice, but these are the people who you are serving also. How do you sort of be involved and come up with possible solutions moving forward and regulation?
Yeah, look, the Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities have been having inquiries into, I suppose, I don't know how they would classify it, but dubious religious practices. So it would relate to some of the points you've mentioned. It would also relate to effectively fraud in terms of the collection of money. So they've still got to, I think they're about to finish, if they haven't finished, but they've still got to produce their report. Then obviously government would look at it. Obviously, if there is fraud going on, then if it's already a crime, then one can deal with it. But you know, it's difficult. I mean, you know, so the Hindus will have, you know, I would see it. Don't know if there are any Hindus here or but so forgive me if I but I would see you know, getting people to do, Hindus as part of their accepted culture would have, or some sects of Hindus would have, the issue of walking over hot coals. I mean, it's a standard practice in Pietermaritzburg over Easter. Now, is that different to making somebody do something else where there's a miracle? You know, so it is difficult. I mean, it's interesting, the Commission got bashed by some of the religious people over interfering, but they still went ahead. But it's a difficult question. But the simple answer, I think, is the Commission have then had this investigation. Let's see what they say with the report. Let's see what can be done. But it's difficult. You know, we do not want to. I mean, look, everybody's bound by the Constitution, including customary law and traditional matters. But religion seems to be exempt. So, if you are Catholic and you're a woman and you want to become a priest, not a nun, or a bishop, you can't. Or an Anglican, there's not only Catholics, Anglicans, whatever, you can't. Is that discriminatory? Yes. Can you take the Anglican Archbishop to court over the Bill of Rights? Doesn't seem like it. So just to indicate that point. But yeah, purple.
I just want to comment firstly on you mentioned spoke about the labor brokers being phased out. Well, it is going to be significantly difficult for government to do that because it has been found that they do contribute significantly to the GDP. So that's why it will be difficult to get rid of them. And then the other issue is the issue of Americana. How significantly has the Department of Justice or government, how are they dealing with the consequences of what happened to the miners, and how are you going to prevent any incidents like that happening again?
Look, I'm not personally involved in the Marikana issues. They're more relating to police mines and the presidency. There is, as far as I'm aware, civil claims have been made against against the police, and there is a process of mediation to try and resolve those matters that's been set up to try and resolve them without going to court. There are investigations and prosecutions into the crimes that were committed, and I did actually on that one ask the NPA for a report, and just a verbal one, and those are close to sort of finality. That's the crimes, and then the broader issues of what happened in the mining industry that gave rise. Those are I think still to be addressed. The one element of Marikana is that, to some extent it was a problem of collective bargaining, in terms of when you have collective bargaining for the whole industry, then everybody wants the same increase. But in Marikana, the rock drillers were the basis of the mine. No rock drillers, no mining. And they were poorly paid. They should have got more. But the unions couldn't argue for more for a particular sector. So that's, to some extent, was one of the contributing factors for the desperation. That here we are trapped. The labor system is not helping us. What do we do? So that's also an interesting point. But I think then I better leave it before I get kicked out. It's been very interesting. Thank you for your questions. I've really enjoyed it. There's policy issues. Maybe to throw some out. One of the hot ones which trying to sort of avoid this, well, not trying to avoid it, can't avoid it, but adult prostitution, should it be legalized? And there's going to be we're going to be releasing the Law Reform Commission report. There's also in policy issues, I forgot to mention that, sometimes government will have research bodies. So in the case of legal issues, we've got the South African Law Reform Commission, which is an independent body, but the members are appointed by the president and paid for, but they get asked to research issues. So they were asked to research adult prostitution or sex workers. Their report we will be looking at releasing hopefully in the next few weeks, which will not be saying this is government's position, but throwing it into the public domain. We gave them another topic, specifically in legislation in the Legal Practice Act, where we were concerned about the high cost of litigation. So rather than trying to tamper with it, and because you'll have some lawyers who are earning lots and lots of money and others who are not. So we then said, no, rather the law reform, put it into the Act, that the Law Reform Commission must investigate this and give us a report within 3 years around what happens in other countries and how can the cost of litigation be reduced. So that's another element. But but when it comes to public hearings on adult prostitution or sex work, there's going to be a lot of noise. Who do we listen to? You can't, and it's not going to be, okay, where is it the one of the people who shout the most are the ones that we must be listened to. It's not even maybe going to be the majority. Okay? As I said, the court has said we have to listen, but we don't have to implement. The majority may not be right. There are things in our constitution that the majority definitely don't agree with, but they're rights to protect people. So the right to life and the abolition of the death penalty. If you had a referendum, most people would support the death penalty probably, but we feel it's not right. And it's in our constitution now, so it's protected by a 2/3 majority. You can't remove it. Yeah. All right, thanks again.
So on behalf of all of the fellows, I'd like to thank you for giving your time to us, Honourable Jeffery. I think your depth of the Constitution is not hollow in the least, and if everyone could join me in a round of applause.